So essentially what this amendment is doing is adding in the phrase Aboriginal heritage wherever the list of prohibited grounds of discrimination occurs in the Act. This is springing directly out of the recommendations that were done by the Sheldon Chumir Foundation for Ethics in Leadership. And the points that they make around this is that for Aboriginal people, it is not clear to them that the human rights legislation is there to serve their people as well as others, that there is confusion as to whether this legislation applies to them at all. And for a number of us that deal with these issues all the time, that would seem to be pretty clear. Human rights legislation is supposed to cover everybody, and specifically to cover those groups that have traditionally experienced a particular kind of discrimination, whether that's withholding of services or difficulties in finding employment or housing. And in fact, given the language that we currently have, there's an argument that Aboriginal peoples would be covered under the phrase that's used race or under ancestries. And both of those words appear in the list of prohibited grounds of discrimination. But what Sheldon Chumir found was that there is a lack of understanding that the human rights legislation does apply to Aboriginal peoples, and furthermore that there's a real reluctance for Aboriginal people to go to the Commission to take advantage of their services. The Commission goes on to say, and for this group of people, they are the group that face the most severe discrimination. And that this is the group that is could most benefit from the Commission's services, and yet is the least likely to seek those same services out. And what the Sheldon Chumir Foundation believes is that the Human Rights Commission and the legislation could be more useful and accessible. And I'll just quote a section. The Alberta Human Rights Commission may be made truly useful and accessible to Aboriginal people in the province, while we, that's the Sheldon Chumir Foundation, recognize the difficulty of responding to this challenge. There are changes that could be made to signal that the provincial government is serious about protecting the dignity of Aboriginal people. For example, in Nova Scotia, discrimination on the basis of Aboriginal origin is explicitly prohibited by law. And they argue that Aboriginal heritage should be added into the legislation. In fact, it appears as Recommendation 12 out of their report. And it was one of the areas that really struck me. Clearly, in Edmonton Centre, I have a number of urban Aboriginal people that live in the riding, and many of them, I will say up front, are very successful. But there are also those who are not, and seem to struggle in many ways to be able to take advantage of the services that are there in ways that other people from other identifiable disadvantaged communities don't seem to have the same difficulties with. And so in looking at that and looking at what was possible under this human rights legislation while we've got it open, I thought this might be an area where we could improve on the Bill 44 and what's proposed under Bill 44, and therefore I'm happy to move Amendment A2, which does request that Bill 44 be amended in sections 3, 4, 5, 6, 7, 8, and 13 by striking out the family status or sexual orientation wherever it occurs and substituting family status, sexual orientation, or Aboriginal heritage, which brings in that Aboriginal heritage phrase and is more inclusive and clearly identifiable to members of that community. So thank you for allowing me to move that amendment, and I hope that I can get the support of the Assembly in passing this amendment.